Wadsworth.
Thank you, my Lord. I did say I would address my Lord Snowden's pleading point. When I introduced paragraph 23 of the affidavit, the element of self-dealing, the question was that part of the case put? If one looks in the core bundle at page 148. This was the draft that was produced at trial with a view to bringing in a case of dishonest assistance. The judge refused permission for a dishonest assistance claim to run alongside the knowing receipt claim, and the appellant does not have permission to challenge that decision. In the judgment, well, let's stay where we are. Paragraph 5A on page 149 was an attempt to react to the joint venture aspect that had become clear in Mr. Crosby's witness statement for trial. And so the proposal at 5A was to say that the payments for the improper purpose of benefiting the first and or second defendant and or Austin Fergus personally, for the reasons disclosed by the second defendant in his witness statement for trial, paragraphs identified, and in any event, not in the best interest of the beneficiaries. In the judgment...
Sorry, can I just ask, is this a paragraph for which you did get permission to amend? No.
No, because in the judgment, at paragraph 211, all the proposed amendments were taken as one piece, and so they were all pursuant to trying to bring in a different cause of action. Because the judge had already rejected the breach of trust and the knowing receipt claims, he said it was academic, it didn't arise. The judge's decision was attempted to be challenged. We don't have permission on that ground, but notwithstanding that, I would suggest it's hard to take a pleading point against the appellant on the basis that the appellant did seek to react to the element of self-dealing which had been brought forward by Mr. Crosby. So, because there is that reference in Mr. Crosby's own evidence together with what was said on the transcript of the call, I would submit it's still a permissible argument to examine the evidence as was available at trial, and that element of self-dealing, because of the further plan to combine for the joint venture to build out to 10 units, must be open to the appellant to rely upon that as a further aspect or element of the breach of trust.
Why? Well, you didn't get permission to run any pleaded case of self-dealing, and you don't have permission to resurrect it in the Court of Appeal. And you can rely upon the facts in support of a different claim for breach of fiduciary duty, but not that one.
I was trying to make that submission off the back of paragraph 211, which is that the judge said, look, there's just no room for a dishonest assistance cause of action. We didn't get permission to run dishonest assistance. There's no permission to challenge that finding, to challenge that dismissal of that cause of action on appeal. But it's going too far to say, given that there was evidence of an element of apparent self-dealing, that can't be brought to the court's attention as part of as an incidence of the breach of trust.
The question is whether you can criticise, that I raised, was whether you could criticise the judge for not having found that there was an element of self-dealing in circumstances where there was no pleaded case in front of him which alleged self-dealing. I mean, trial judges just, they adjudicate on the case as pleaded.
Yes, of course, but what I'm submitting is that paragraph 5A was the attempt to inject that element into the case, but the judge treated the proposed re-amendment as all part of trying to bring in a dishonest assistance cause of action, and it wasn't just a dishonest assistance cause of action. 5A was a reaction to the element of self-dealing.
Well, we got your trial closing submissions in the supplementary bundle, although I confess I haven't read them. Is there anything in them about self-dealing as distinct from dishonest assistance?
Page 295, paragraph 14. This, as is clear from 292, this was a summary document which was intended to be used as a speaking note, rather than it's not a full written submission. We would perhaps have to examine the transcript of the closing itself, but there was clearly a reaction at trial, both in the evidence put to Mr. Crosby and then in closing, about the joint venture aspect that Mr. Crosby's evidence had revealed. It was the subject of examination.
Right, but this is all part and parcel of the intention to benefit a non-object, isn't it? I mean, that's apparent from paragraph 15, isn't it? You only I mean, it's the point. I mean,
well, I'm entirely realistic in the face of my Lord's observation, but when we had the discussion about aspects of fiduciary duty as per Bristol and West, and this being an incident of a breach of fiduciary duty, an element of self-dealing, it wouldn't be right to say, well, that just wasn't put on the agenda. There was an attempt to put that on the agenda, both in the evidence that was being tested and the proposed re-amendment. The question of amendment really became academic in the judge's mind, because none of it's going to arise. You've not proved breach of trust, you've not proved knowing receipt, so dishonest assistance won't get out of the blocks. But now we're examining the material which founded a breach of trust. That is part of the material that was there and present, based on Mr. Crosby's own evidence about what the part 2 of the agreement was.
I mean, is there anything in your skeleton argument for the appeal about a self-dealing case? I don't recall reading those words, but I might have missed them.
No.
Well, we've got to be realistic.
Yes.
This is not a case which was run to the judge and is not a case in your skeleton. You've got lots of good points, which Mr. Lord Justice Lewison has said you could argue. Maybe you should concentrate on those.
I understand. I was trying to be comprehensive and certainly responding to the point. The pleading point is now clear. We've seen what was permitted in the pleading and what wasn't. We return then to, having covered the ground of breach of trust and what the breach of trust might consist of, the question of knowledge. And Lord Snowden has pressed for an examination of the appellant's case as to knowledge of what. And before lunch, I was suggesting that we can simply assess the breach of trust question, park that question, and then the focus turns completely to what the defendant's state of knowledge was. And that's where Lewin and how Lewin assesses Baden 1 to 5 is, we believe, of some assistance. So in the first authorities bundle at page 134, Chapter 42, 072. common ground between my learned friend and I, and accepted by the judge, that categories 1, 2 and 3 are all actual knowledge. 1 being actual knowledge per se, 2 being willfully shutting one's eyes to the obvious, 3 being deliberately reckless as to not making the inquiries that an honest and reasonable man would make. They are all the equivalent of actual knowledge per se. And then as to categories 4 and 5, 4 being knowledge of circumstances which would indicate the facts to an honest and reasonable man, and 5 knowledge of circumstances which would put an honest and reasonable man on inquiry. 4 and 5 may also turn into actual knowledge by examination of the manner in which the defendant deals with the evidence and whether evidential burdens can be discharged or not. So in essence, if a defendant makes a poor job of explaining their conduct, the questions that they could have asked and did not ask and so on, then that may shift the evidential burden to them, and if they don't discharge it, then there's an inference of actual knowledge even through categories 4 and 5. In the judgment at paragraph 207, by reference to this extract in Lewin, the judge accepted that category 4 or 5 knowledge is capable of founding liability. So the way we approach it, consistently with the way the judge approached it, is to deal with the question of breach of trust as between Austin Fergus and the beneficiaries on one side, and then examine the state of the defendant's knowledge and the conscionability of what the defendant, or how the defendant is explaining his or her conduct. In terms of the granularity, as I made clear before lunch and do not go back over, the paragraphs 36 to 39 of the skeleton argument are what the appellant relies upon. When one looks at the questions which are posed at paragraph 37, they are, we would submit, all category 3 questions, and failing to ask them represents recklessness on the part of Mr. Crosby. An honest and reasonable man would ask those questions. If we're wrong about that, then they are category 4 questions. They are things which indicate the facts to him were he to be an honest and reasonable man. That put an evidential burden on Mr. Crosby, which we say could not be discharged on the evidence that Mr. Crosby brought forward. My learned friend seeks to bring into this exercise the dishonesty test in Ivy as making a material difference to the examination of the defendant's knowledge. But the question is knowledge of breach of trust through categories 1 to 3 or 4 and 5 if they create an evidential burden which can't be discharged. It's not for the appellant to prove a dishonest denial of knowledge by Mr. Crosby. That's not the test. That's not the hurdle that the appellant has to overcome. So the attempt to introduce Ivy, we would say, would only really bite if dishonesty were an important element of the cause of action. So if it were a dishonest assistance claim, which was not permitted, then Ivy may make a material difference. But if you're just within Lewin at 42-072, then we would submit that Ivy doesn't disturb things. Ivy, as we know, just reset the dishonesty test. In Gauche, it was the conduct dishonest by the standards of ordinary decent people. did the defendant subjectively realise that ordinary and decent people would regard it as dishonest? IV, it's been reset as what is the actual belief and knowledge of the defendant, and can their conduct be seen to be dishonest by the standards of ordinary and decent people? That, we submit, doesn't intrude here. We just apply the categorisation of knowledge that Lewin suggests at 42-072.
Sorry, can I just pause for a moment before? I'm not sure I do find this categorisation very helpful, I have to say. Certainly not without having it in front of me. Is the test for knowing receipt one which is subjective or objective? In other words, are you investigating the state of mind of the recipient? To which the answer, I think, is presumably yes, you are. Yeah. But when you talk about the honest and something which would have been obvious to an honest and reasonable man, what is the? Are you saying that the state of mind of the recipient is irrelevant? I'm struggling with the. I'm struggling with what you're saying here, because I understood the test to be one where it's been said that the test is whether it is unconscionable, the state of mind, whether the state of mind subjective of the recipient makes it unconscionable for him to retain the benefit. And I mean, are you saying that that is not the test? Are we going back to those 5 states of knowledge? I'm just struggling to get the legal context into which you're making these submissions.
I understand.
Specifically, BCCI does discuss the Baden test.
Yes.
With some qualifications. So, what you should be doing is focusing on this single test.
Yes, I was suggesting that the answer might be in what Lord Sumption stated in Papadimitriou, which is page 126 of Bundle 1 of the Authorities, which is to firstly align the test for knowing receipts with the test of bona fide purchaser for a proprietary claim. The test should be applied in the same way. And on page 127, just below letter B, there must be something which the defendant actually knows.
Well, before you go below letter B, can you just go above above B? I mean, he says we are in the realm of property rights and are not concerned with an actual duty to investigate. What does he mean by that?
It's hard to reach a clear conclusion just on that phrase in isolation. It follows from the last line on page 126, I think, that there's little assistance from older cases in which judges have asked what's the shape of the duty to make inquiries and how far does it go on the facts of any instant case. Then a day it says ultimately there's little to be gained from a fine analysis of the precise turns of phrase. It's step away from the question about what are the inquiries that should be made as such. And it's really a prior question of whether the defendant has established such absence of notice as entitles him to assume that there are no adverse interests. And that question should be applied both to a proprietary claim and to the knowing receipt claim. And then that is explained. So the mere possibility that such interests exist aren't enough. There has to be something which the defendant actually knows, or would actually know if he had reasonable appreciation of the meaning of the information in his hands, which calls for an inquiry.
I mean, this is not a knowing receipt case, just to be clear.
I think my learned friend and I at trial both alighted upon this case to say, for the personal claims and the proprietary claims, we can take the test as equivalent, which the judge accepted. And I think...
Is that relying on only on this judgment of law assumption?
Well, we have certainly isolated that particular proposition from that singular speech.
Page 126.
Yeah, thank you. I'm looking for clarity on the extent to which there was agreement.
This was a question, paragraph 2 of the judgment. This is a proprietary tracing claim.
Yes, it was originally put 3 ways: dishonest assistance, knowing receipt, and a proprietary claim. They all failed before the Chief Justice. The claimant didn't appeal the dismissal on dishonest assistance or knowing receipt.
And so the question is whether the bank was on constructive notice of impropriety.
Yes, can it show it was a bona fide purchase of
value without notice?
Without notice.
Right.
But then at 33, that's a putting together of the test in any event, which...
What's the authority for that proposition that it's the same? That it's the same test.
The reason I queried it is because BCCI has it in the Court of Appeal draws a distinction between notice and knowledge for knowing receipt purposes.
I mean, notice is a fundamentally a sort of conveyancing issue, isn't it?
Yeah, I was just pausing to just before I forget, to just capture how the judge approached it. And actually, I don't think it was by reference to paragraph 33 of Papadimitriou. If one looks at paragraph 204 of the judgment, the judge took BCCI and Akindele to say that the acid test of one of unconscionability by reference to the fivefold classification of knowledge, and then the Lewin point about 1 and 3 are actual, 4 and 5 may turn into actual. That's at paragraph 206.
Yeah, I mean, but see, if you go back to page 135 of the authorities bundle, to the extract from Lewin, and read 4273 and 4274, the highlighted passage pretty clearly indicates that notice is not the relevant criterion for determining liability for knowing receipt.
Yes, Malone Friend in his skeleton covers this ground quite crisply. So paragraph 13 of Malone Friend skeleton, page 60 of the core bundle. Paragraph 13, he relies upon Papadimitriou. Paragraph 14, he relies upon BCCI and Akindele, which is the acid test is unconscionability, which is what the judge said. Then I say he drifts into error by introducing a subjective and objective element to dishonesty as per Ivey. That would matter if dishonesty was part of the cause of action, but not, I say, on the question of knowing receipt. So I say that's an error.
Well, okay, it'll be, okay, this isn't your skeleton.
No,
I'm not entirely sure. I have to say that paragraphs 13 and 14 are the same, or at least consistent at the moment.
My lord, I understand. I'd approached it through the summary in Lewin.
I mean, speaking for myself, I mean, I've never really understood, other than in a conveyancing context, the concept of notice as opposed to knowledge. Knowledge I can understand. You either know something, or you turn a blind eye, because in essence you know what you will discover if you ask the question, which is treated as tantamount to knowledge. But once you start getting into questions of, well, you know certain facts from which it is to be assumed that you should have asked questions to discover something else which you didn't know, then that's where we do get into the more difficult areas. But none of that is dependent upon concepts of notice. It's that if you know A and B, an honest and reasonable man in your position would ask the question C. And if you don't ask the question, the legal issue is why not and what consequences flow from it. I'm not sure we really helped very much by starting to drift into areas of notice. That's in this area. At least I need to be educated as to why notice as opposed to knowledge is any different. And if what you're really dealing with here is the question of knowing what he knew, why didn't Mr. Crosby make inquiries? And what inferences can we draw from his failure to make inquiries? Then I'm not sure it helps us any to go in to discuss matters by reference to notice. It's much better to sort of address them by reference to whether the judge was justified in his conclusions about whether Mr. Crosby should or shouldn't have asked questions, and if he had, what he would have discovered and why he didn't ask them. I just don't know why we're just spring down a rabbit hole of notice at the moment. That's just my experience.
It may be, and it may be that the orthodox approach is to just apply Lewin, assuming that passage accurately states the law, 42-072. Look at what somebody in Mr. Crosby's position would have done as an honest and reasonable man. Was he reckless in not making inquiries? Did he ignore the indication of facts to him as an honest and reasonable person? Or was he put on inquiry and still didn't ask questions? Paragraphs 36 to 39 of the skeleton are the granular factual ingredients for why we say he acted unconscionably. And there's an attempt by Lord Sumption in Papadimitriou to say, certainly the way it's expressed on page 127, that it is actually the same. Because if even without inquiry or explanation the transaction appears to be a proper one, then there's no justification for requiring the defendant to make inquiries. He is without notice. Whereas if the transaction does not appear to be a proper one and you need to make inquiries in order to ascertain whether it is a proper one or not, then you are on notice, and then the failure to make the inquiries is indicative of unconscionability for the purposes of knowledge and how you get there, and through which category do you get there. Now, I confess we have not put before the court, neither of us, I don't think, further material which might explain to what extent that attempt by Lord Sumption has been regarded as helpful or not, or whether to what extent it's been followed. But clearly that's something I can attend to overnight. I
mean, it's clearly he was not making a decision on this issue of knowing receipt, whereas BCCI does. That's binding on us.
Well,
establishing the test.
Yes.
Maybe unless you can point to something that actually doubts that, is it as simple as seeking to apply that test?
No, it makes no material impact to the appellant's appeal.
Right.
In Akin Daly, that's in the third bundle. It begins at page 800. And it's worth just flagging up because it then it gives a reference point for the 5 categories of for the fivefold categorisation in Baden. We see that on page 817, whereas I don't think we actually do see it in the Lewin extract, so we've got to look at it somewhere. I have rehearsed it faithfully, but that's where it is rehearsed authoritatively.
So the Baden classification is in Lewin.
It's at page 817, letter D.
Sorry.
Yep. That is at least where we have the fivefold categorisation set out, and then the marked passage is on page 818, bundle 3 of the authorities. Lord Justice North saying, we should now recognise that there is a single test of knowledge for knowing receipt, and that is simply this: the recipient's state of knowledge must be such as to make it unconscionable for him to retain the benefit of the receipt.
Okay, can I just draw your attention to letter B towards the top of the page, where there's a doubt raised about the utility of the Baden categorisation in knowing receipt cases?
Yes, the reason why I haven't jettisoned it entirely in this appeal, what the Court of Appeal appear to be saying in BCCI is that it can prove to be formulaic or cumbersome to decide, well, are you saying it's 3 here and 4 there? Yeah. One could see that. It sort of could become a tortuous exercise. The reason why it can't be jettisoned is because there is some value in the judge recognising in this case that you may get actual knowledge through categories 4 and 5 through the shifting of an evidential burden, yes, which is not discharged.
I think we've got you.
So it's expressed helpfully in that way,
Yeah.
And then obviously that chimes with what Lewin says at
Yeah.
-072. But to look at how neatly it's postulated by Lord Justice Norse in Akindaly here on page 818, it's a very deliberate policy step away from any sort of formulaic approach. It should be left to common sense decisions in the commercial context in which the question arises. You know unconscionability when you see it, which is certainly very similar to what Lord Sumption was expressing in Papadimitriou. The legacy cases can involve unhelpful mental gymnastics where there's an attempt to say, well, what are the limits of the inquiries? And it's being said it's not an investigative exercise as such. But what does the transaction look like to the defendant? Does it, without inquiry, look to be proper? In which case, well, that's it. You take it at face value. If it doesn't look to be proper at face value, then you have to go behind it by making reasonable inquiries. And if you don't make them, then you're showing unconscionability of conduct.
But the issue here is, if this is the test to enable the courts to give common sense decisions in the commercial context, in which claims in knowing receipt are frequently made, or whether this is commercial or otherwise, you have to show that the judge's approach to unconscionability on the facts of this case was either the wrong approach as a matter of law or irrational, unsupported by evidence or out with the decision to which any reasonable judge could come on the facts, don't you?
Yes, and
and I don't think. Do you say that the judge applied the wrong legal approach?
I'm checking the exact wording of ground 6. As I mean, ground 6 and ground 7 obviously run together, but permission has been given both on ground 6 and on ground 7. On ground 6, it's a misapplication of the Baden categories as an error of law. The pure postulation of the test by the judge, I have not criticised, and I've explained why not by looking at that part of the judgment. But in assessing the defendant's knowledge as against the evidence that was before the judge has ended up misapplying those categories on the facts of this case and in such a way as to represent an error of law. Because there's a far too benign treatment of the defendant at paragraph 209, where there's impermissible reliance on matters which aren't properly relevant, or there's a failure to take account of and give weight to matters which are relevant. And again, the factual foundation for that is paragraphs 36 to 39 of the skeleton. There were obvious questions which Mr. Crosby was bound to act if he was truly acting as an honest and reasonable man, and he did not.
Let's be clear. I've just read down again paragraphs 204 to 207 of the judgment, where the judge sets out his approach to the legal test. I mean, do you say he was wrong in anywhere in 204 to 207 or not?
No, he's framed the test correctly,
Right.
but he has misapplied the evidence as against the test.
Okay.
Ground 6, word for word, in his assessment of knowledge, the judge misapplied the Baden categories as an error of law.
Yeah, but he didn't test is not the Baden categories. They just are, the Baden categories are at best a helpful analytical tool to think about, makes you think about knowledge.
Yes, so I suppose the other way of expressing the challenge is that a judge could only really have weighed this evidence in such a way that Mr. Crosby, by failing to have asked himself the questions that we've put in the skeleton, was demonstrating unconscionability of conduct. And any contrary conclusion represents a misapplication of the test to the facts, or a failure to give any proper weight to relevant matters and giving too much weight to matters which, in comparison, were irrelevant.
So this, you say, is a Baden Category 5 case. The judge should have accepted that Mr. Crosby knew circumstances which would put an honest and reasonable man on inquiry, and then what, deliberately chose not to make the inquiry, or just didn't make the inquiry?
No, I mean, I already put the questions which we've posed in the skeleton as Baden Category 3, and if not 3, then 4. We say it ought to have been obvious to the judge that Mr. Crosby was acting deliberately, recklessly in not making any inquiries. Well, Austin, whose money is it? Do they know what you know? Are they happy to lend it on undocumented terms?
So
that's not just.
So you say this is a Baden. The judge failed to appreciate this was a Baden Category 3 case of willfully and recklessly failing to make such inquiries as an honest and reasonable man would make. That's Baden 3.
Yes, it's not 2. I can't go so far as to say it's not willfully shutting one's eyes to the obvious, but it's very close based on the material that we've pulled together. But it is 3. There is knowing recklessness of which he ought to have appreciated he was acting recklessly in not making the obvious inquiries which an honest and reasonable man would have made.
Well, reckless, as I understand reckless, it's recognising that there is a risk and then deciding to go on with
and not caring what the answer to the question is. But I accept that ultimately the categorisation is subordinate, as per Akindele, to was Mr. Crosby unconscionable or not, by reference to the picture, the evidential picture, and what he could or couldn't say in defence of his conduct based on what he did and didn't do, what he did ask and didn't ask. Certainly the difference between my learned friend and I is this attempt to bring Ivy in to disturb the question. I say that's wrong for the reasons I've given. And my learned friend in his skeleton at paragraph 19 page 62 core bundle is critical of the permission order. Permission was given on ground 6 simply on the basis of what the check would have indicated to an honest and reasonable man. And my learned friend says, well, that's not enough. But we're back where we started. I said, actually, when you examine Mr. Crosby's own evidence and you examine the contents of the transcript, there was far more to this case than simply what appeared on the face of the check. An honest and reasonable man would have asked the question based on the check. The check says SPH Trust, but the judge was indulgent of Mr. Crosby. And this is a finding of fact which can't be disturbed. The judge said, he told me he didn't notice, and I accept he didn't notice. So the appeal's not being run by trying to overturn that.
Why would the honest and reasonable man make inquiries about something which he had not in fact noticed?
Yes,
I mean, how could he?
quite.
If he doesn't see that it says
Quite.
SPH Trust.
Yes.
What inquiries has he got to make?
Well, that's why I've left that completely out of the question. That's not part of the skeleton argument. That is a finding by the judge. He says he didn't notice, and I believe him. We're stuck with that. The permission order considered that, in fact, even though he said he hadn't noticed, nevertheless, it may be arguable that a reasonable person would have understood that the money was not Mr. Fergus's own money. I've taken that and elaborated on it significantly in terms of the other material that put significant scrutiny on the state of Mr. Crosby's knowledge.
Yes.
So we've honed in on an example which shows the distinction. I'm not trying to persuade this court that when the judge said Mr. Crosby told me he didn't notice and I believe him, I'm not persuading this court to change that. I can't. But my learned friend is wrong to say, oh, it's all a matter for the judge, really. It's not a matter for the judge if the evaluation can be shown to be wrong. And the evaluation of the material that we've seen, that was before the judge in the evidence, set against the acid test of unconscionability, we say the judge must have gone wrong. The evaluation reaches the wrong conclusion, and it's got there by leaving relevant matters out of account. So, in the judge's review at paragraph 209, Mr. Crosby trusted him, long-standing professional acquaintance. Mr. Crosby's not very sophisticated. And so on. They are nowhere near half the picture. The rest of the picture, we say, was amply before the judge in the questions that we've summarised that an honest and reasonable man would have had to make, and Mr. Crosby plainly didn't.
So just to be clear, are you saying that any of the things that the judge took into account in paragraph 209, 1 to 8, were matters that he should not have taken into account?
No, I can't say that, but they can't be taken into account without taking other things into account, and they have to be set against the other things.
So the things that he should have taken into account, but you say didn't.
And they eclipse the things that he has taken into account at paragraph 209.
And where are they set out? Most clearly, most just my note.
In the appellant skeleton argument, paragraph 36 to 39. Together with the annotation that I've put against paragraph 36 as we looked at it earlier.
Is this right? You say that you say that taking into account these additional matters, that no reasonable judge could have come to the conclusion that the judge did.
Yes, he had to conclude that Mr. Crosby had acted unconscionably. By failing to ask all those questions, notwithstanding the matters which point to an indulgence of Mr. Crosby at paragraph 209, nevertheless it's clear and plain that there was unconscionability. As to paragraph 39, actually, I just would mention, insofar as the transcript of the call showed that Mr. Crosby was aware that other clients had received money, Mr. Lynch was mentioned on page 5 of the transcript. Mr. Ahmed was mentioned on page 16 of the transcript as being somebody who Mr. Crosby understood to be a gym owner. Mr. Ahmad was a witness statement for trial, and at paragraph 12 of his witness statement, supplemental bundle, page 175. Actually, now I've started on this point, we should probably pick it up at paragraph 8 on page 174. Mr. Ahmad received a call from Mr. Crosby. Paragraph 9, he believes that Mr. Crosby must have got his number from somebody who knew Austin Fergus. I don't need to go into detail as to the content of the conversation since the recording is available. Mr. Ahmad, having said he wasn't sure why Mr. Crosby was calling, so he decided to record it. Over the page, paragraph 12.
That seems a very strange thing to do. Was he cross-examined about that at all? Why he recorded it?
I can't recall, but on the basis that everybody knew it had been recorded and therefore was the subject of a transcript, it may have been thought to be a sterile line of questioning. But,
no, I just think if you have a call from someone, you've no idea why they're calling. You think, oh, I better record this. It just seems an odd process of thought. But anyway, there we go. Sorry, what else did you want us to look at?
Well, it's true. Paragraph 12 really is the point, page 175. And I mean, I quite accept, as to paragraph 12, yes, but it's when did Mr. Crosby know certain things? Did he know them at the beginning or did he know them later? Nevertheless, it's some ingredient that was worth going to, because Mr. Ahmad said, look, he says to me on the call, there could be trouble if everything is traced back from Austin Fergus. And all these things were, there was an attempt to give Mr. Crosby the chance to address these things. The cross-examination went, as I say, fairly methodically through the transcript. What did you mean by saying this? What did you mean by saying that? The court has those notes to be able to consider in due course. I was simply going to the end of paragraph 39 to make sure that it's not left out of account. We say that that's ample material which the judge had to grapple with if he was to properly apply the test of unconscionability. Had he done so, he would have had to conclude that this was a man who deliberately asked no questions because he didn't want to learn the answer. I'd propose to move to ground 9.
One difficulty I've got here, just before you move to ground 9, is we haven't actually been shown any evidence that was given by way of cross-examination on any of these topics. I mean, you've asked us to look at bits of witness statements and bits of a transcript, but we haven't heard the cross-examination over several days, presumably, as the judge did, who had the grasp of all the evidence.
Yeah, well, we say you don't. We say you don't suffer a material disadvantage when you actually apply paragraphs 36 to 39 and look at how the judge reached his conclusion on knowledge. That the court can still comfortably see that it's an impermissibly benign treatment of Mr. Crosby's evidence. It's everything that's cited in paragraph 209 points one way and one way only, which is in a way which is favourable to Mr. Crosby. Well, he's been introduced to me at trial as a rough diamond. I find he's not very sophisticated. I find he had a high level of trust in Austin Fergus. It's been suggested there was no good explanation for why everything was upended when Austin Fergus disclosed his cancer. I don't accept that. I can well understand why Mr. Crosby might have felt uncomfortable. I take account of the evidence that there was an offer to pay a fair share, but I put that offer in context. Every part of the judge's exercise, having set the test, but every part of the analysis, it's simply a collection of things which are favourable to Mr. Crosby. Well, as I've conceded, you can't say that they don't have a foundation in the evidence, and you can't say that they can't form part of the analysis, but they can't form part of the analysis if you end up jettisoning all the other matters, the obvious questions that Mr. Crosby ought to have asked. And if you come down on a balanced consideration and say I've now taken account of all these things that might appear obvious for somebody in Mr. Crosby's position to ask, but I've reached a good explanation for all of them, and there are these further indications which give me further comfort, that would be it would represent a completely different judgment. But we say you just can't carry paragraphs 36 to 39 of the skeleton into the judgment, whether at 207 or anywhere else. And that's why grounds 6 and 7 can prevail, either because of misapplication of the evidence to the test, or ground 7, just the evidence hasn't been weighed properly as to what would put an honest and reasonable man on inquiry. Ground 9 is the question of remedy against a personal remedy against a knowing recipient, and here we say there is some tension in the law, as we'll see, but the starting point and the authority which I have to confront is novoship, which is in bundle 3 of the authorities. Beginning at 913. And cutting to the quick, we identify a relatively nuanced error here made by the judge. So paragraph 107 of novoship, page 947. It's the Court of Appeal saying, we know there are some suggestions that you can treat an accessory as the equivalent of a trustee, so the equivalent of a fiduciary. However, at the end of the day, an accessory is not a fiduciary. The fiduciary owes the prior duty, the accessory doesn't. one liability stems from the duty that you owe in the first place, the other, the accessories liability, stems from a different place, which is the question of wrongdoing. And at 107, it said, well, if you're not a fiduciary, you're not a fiduciary, and that is an important and relevant distinction. You're being sued because you've committed an equitable wrong, not because you owe a prior duty. And so it is said that there is no reason why common law rules of causation, remoteness, and measure of damages should not be applied. Because ultimately, the Court of Appeal in Novaship conclude that there is a discretionary element to the personal remedy against a knowing recipient. And the causation question, no reason why you can't bring that in, is an element of the discretionary approach. Whereas the judge at paragraph 213 has gone further than paragraph 107 of Novaship and suggested that there is actually a hard-edged prior question of causation first. And if and to the extent that you get over the causation question, then there are residual discretionary elements. And we say with respect to the judge, that's not what's being said by the Court of Appeal at paragraph 107. And so the judgment at paragraph 2131 takes Novaship too far.
Sorry, the court in Novaship considered discretion under a separate heading. I just want to make sure I've understood what you're saying. Are you suggesting that all they're saying at 107 is as part of that discretion you can decide whether to apply conventional common law causation rule?
By reference to other authorities, which I'll come to in a minute, okay. I'm suggesting that that ought to be the proper approach, and that there should not be a distinct intermediate step, which is to actually apply common law causation first, and then move on to consider other discretionary elements. It's all part of the same consideration as to what should be the appropriate response to the misconduct, and what should the remedy be as a matter of discretion. And at 107, the language is clear. No reason why it shouldn't apply, but that is not a positive endorsement of it must apply. And yet the judge at paragraph 213 has reversed it, and at 2131 brings it in as a defined intermediate step. And we submit that that's wrong. The reason is because in an appropriate case, we submit that disgorgement of profit ought to be on the menu. And ultimately, the factual assessment will determine whether a disgorgement of profits is something that should apply to a knowing recipient or should not. But, I mean, disgorgement has obviously got nothing to do with question of causation, and that's why we say the judge has erred.
Which bit of 213 do you say is wrong? Because in 2131, the judge says there's a requirement to go further than satisfying a but-for test in respect of causation. Do you agree with that?
Not necessarily, for reasons which I'll come to.
Okay, because in 114 of Novaship, the Court of Appeal said in our judgment the simple but-for test is not the appropriate test. So I'm struggling to understand why the judge is wrong in the first part that I've just read to you.
That's a fair observation.
Okay.
Which
then he says it's necessary to show more of a causal nexus between the misconduct and the profit, and in particular the misconduct was an effective cause of the profit being made. I mean, that's just a statement of law of causation, isn't it? Which is very similar to what the Court of Appeal say in paragraph 114 in Novaship, where they talk about a distinction between the occasion to make a profit and the real or effective cause of the profits. I mean, that, I think, the test of causation at common law is the real and effective cause, isn't it?
This is my starting point. We still say there's a difference between what's said at paragraph 107 and what the judge actually did and the test that the judge introduced. we say there's a difference. Your Lordship may be saying it's a difference without distinction. One is dancing on the head of a pin. I take full square the observation that's just been made. Novaship is not the last word on this in any event, and that's why I started off by saying that we may here confront some tension in the law, which needs to be resolved. But for the start of this line of argument under ground 9, I detect a difference. I criticise the judge for the difference, and say ultimately why the difference is wrong is because in an appropriate case, as against a knowing recipient, you may be able to look at the knowing recipient and say you must disgorge the profits that you've made. And to have a causation test as an intermediate part of the test removes that possibility, and we would say removes that possibility wrongly. Because for the reason that the Court of Appeal express in Novaship, a knowing recipient does not owe a prior duty in the way in which a fiduciary does. And a knowing recipient is not necessarily dishonest. But Mr. Crosby, as with another notional knowing recipient, had a choice to make, which is, do I return the monies or do I retain them? Do I do the right thing or do I do the wrong thing? He chose to retain them and gamble with them on his confidence that he could make a profit. But in doing that, he had no appreciably greater virtue than a dishonest assistant or a fiduciary who'd misapplied the money in the first place.
Well, but hang on. Wait a minute. I mean, the whole point about Novaship is to say there is a difference between somebody who's a fiduciary, who isn't entitled to do any of the things you just said, and somebody who's not a fiduciary. I mean, as the Court of Appeal put it rather bluntly at the end of paragraph 118, at the risk of tedium, we repeat that Mr. Nikitin was not a fiduciary and is not sued for any breach of fiduciary duty.
Yes, quite. So if the result would have been different as against a fiduciary, that's fine. That's because that person is a fiduciary and a knowing recipient isn't.
Okay, so I really am struggling here.
So
what they are saying in Novaship surely is, if you are looking at what remedies are available against a knowing recipient,
yes,
there is a requirement which is different to the requirement which you would apply as regards the actual delinquent fiduciary, and it's a requirement of causation. I mean, we're bound by that, aren't we?
well, it may. This court may, on reflection, on revisiting these questions, may say the distinction is not. It's not necessarily a sound one, and it may not hold water, because when the other cases say, well, when you say treat them as a trustee, as akin to a defaulting a trustee, it should actually mean exactly that. Well, then there shouldn't be a departure in terms of the remedies.
Okay, so are you going to show us some decisions which were not
well, I'm going to draw out
cited in Novaship, which you say means that Novaship is per curiam?
I'm going to make an attempt to draw out the tension that I said exists.
Okay.
And I said at the beginning, I confront Novaship head on because there's complete clarity in what's said in Novaship, even as my Lord has pointed out. It's 118 to 120. If the complaint is yes, but this would have been a different result as against the fiduciary, well, that's absolutely fine. The reason why it's not the result is because we're not dealing with the fiduciary. That's the distinction. That's what we need to test. The basis for beginning to think about testing it is, as I say, to think about the respective degrees of virtue. Why, if somebody has known that they've received funds which have been misapplied in breach of trust, why does that person who has an awareness or is taken to have an awareness by reason of their unconscionability in respect of their knowledge, and they deliberately refrain from returning the monies, if they have got no appreciably greater virtue than the dishonest assistant or the original misapplying fiduciary, where does the basis for the distinction come from? The judge, in terms of capturing his intermediate element of causation, was attracted by, yes, but Mr. Crosby used his skill, his nous, his understanding of the location of the property market in order to be able to effect a very lucrative sale to McDonald's once the build-out plan fell away. But one has to be very careful, because that nous is part of Mr. Crosby's own sort of warped moral justification for deliberately keeping the money in the first place. That's why he accepts it as a tolerable gamble. For him to say, well, I know it's somebody else's money and I know it should be restored to the recipient, but I'm going to keep it anyway. And of course, he's only able to say any of these things once the gamble has paid off and he's been able to flip it successfully for a circa 1.4 million profit. I will turn to other authorities which touch upon the same territory in order that novoship is set in proper context momentarily. But could I just start at paragraph 49 of the skeleton? Of the skeleton, yes.
Okay, why is this relevant?
May I just take a moment to go back to Akindele to see. If we look at the three categories of wrongdoer alongside each other, so the defaulting fiduciary, a dishonest assistant, and a knowing recipient. In respect of the dishonest assistant, there is authority for the proposition that the dishonest assistant should not expect to find himself in any better position than the defaulting fiduciary. And if that's correct, then the question arises, well...
What is the authority for that?
I'm sorry, my lord?
What is the authority for that? Because that seems to be contrary to novoship, isn't it?
Directly.
Within Lewin, it's by reference to Madoff Securities against Raven, and I've left the extract in the skeleton together with the other cases, which I appreciate are all first instance decisions. But for that to be the conclusion of the leading text merits at least some consideration. So it's the beginning of an assessment as to why should the remedies be different as against the fiduciary, the dishonest assistant, and then at the bottom of the chain, the knowing recipient. And there is some authority for the proposition that the dishonest assistant has to be treated the same.
So where is Lewin 4053? Is that the text you left in?
Yes, but it's also in Authorities Bundle 1 at page 197.
Is this talking about loss, or is this talking compensation, or is this talking about account of profits?
Well, as I understand it, it's about measure of liability wholesale, by reference to a comparison between the dishonest assistants and the original defaulting fiduciary.
Yes, but the point is, sorry, this paragraph, we don't have the paragraph that goes before it, but this paragraph seems to be talking about compensation, measure of compensation for loss. It's not dealing with the question of account of profits, is it?
No, my lord, that's true. That may be a material qualification, and certainly the final sentence. It's about to what extent do they align, and if they align, on what basis do they align, why do they align. Certainly the final sentence of 053 is again expressed in terms of loss, but it's a denial of the causation question. I'm doing this in a series of short steps. So, and it's keeping at the forefront of our minds. If there's a difference between the fiduciary, the dishonest assistant, and the knowing recipient, why, where does it stem from, and where does it take us? At paragraph 53 of the skeleton, I then introduced the House of Lords decision in Dubai Aluminium. Which is Bundle 1, page 204.
I mean, I do understand, I think, why you might say that as far as compensating a beneficiary for loss caused by the by a breach of fiduciary duty by a trustee in which you have dishonestly assisted, you shouldn't be in any different position as regards paying compensation. I can sort of understand that as a proposition, perhaps. I'm not sure that it sits very well with the Court of Appeal in Novership, I have to say, but at least I can understand why you might say that.
Yes.
I'm not entirely sure why that, at the moment, that the same thing follows at all in relation to just a knowing recipient of trust property.
No. My end point, I already explained, is I'm going no further than to say disgorgement of profits shouldn't be taken off the menu as against a knowing recipient. There may be cases where that's an appropriate remedy against a knowing recipient, but if you introduce the sort of hard-edged intermediate element of causation question in the way in which the judge did, then you would never be able to get an account of profits against a knowing recipient, and we submit that that's incorrect. The discretionary elements which must apply, I would accept, to an accessory liability may even mean that it's in a relatively uncommon case that you'd go to a knowing recipient and say they're liable for a disgorgement. But there will be some cases where it's appropriate, and obviously we say this appeal represents one of them. As to the obviously clear and manifest conceptual difference between a true fiduciary and an accessory, one is being criticised the law because there's a prior duty, the other is being criticised as a response to some wrongdoing which arises without a prior duty. that difference is obviously fairly stark. The causal connection could be a useful tool to bridge the gap between the duty to account and the liability to account. So the accessory has a liability to account, but it arises through a matter of causation rather than a matter of duty. What I've submitted at paragraph 53 is that the House of Lords in Dubai Aluminium did not seem to worry unduly about the flexibility or equity's flexibility in being able to respond. I refer to paragraph 141, which is on page 242.
Give me the page reference again.
242, my lord. It's paragraphs 141 and 142, which, and here's where we see the tension, because this is against para 107 and following in Noviship, where the Court of Appeal say, well, there's a difference because they're not the same, and so the start point is different. Here it said, it's acknowledged that they were not dealing with an original defaulting fiduciary. The claim against him, Mr. Amherst, was simply that he participated in a fraud. Equity gives relief by making any personally sufficiently implicated accountable in equity. In such a case, he is traditionally, and I've suggested unfortunately, described as a constructive trustee, and is said to be liable to account as a constructive trustee. But he's not in fact a trustee at all, even though he may be liable to account as if he were. If he receives the trust property at all, he receives it adversely to the claimant and by an unlawful transaction which is impugned by the claimant. He's not a fiduciary, therefore he could plead limitation. But the expressions ultimately of liable to account as a constructive trustee are nothing more than a formula for equitable relief. For accountable as constructive trustee, one could simply substitute the words accountable in equity. Then if we look at the Privy Council decision, Arthur against the Attorney General of the Turks and Caicos Islands, in this bundle, turn on to page 252. There's a limit to what weight can be placed on what is said in this paragraph, paragraph 34 of Arthur. It's on page 265. I accept that this may be a relatively small piece of the jigsaw. However, at paragraph 23, it's recognised that once it's unconscionable for you to retain the benefit of the receipt, then that is a species of equitable fraud. And then the Privy Council go on to say, well, in terms of the consequences of knowing receipt, the material distinction is that between proprietary and personal remedies. The personal remedies only really arise where where the proprietary remedies don't work. But the claim for personal liability as against the knowing recipient is also that the recipient must account as a constructive trustee. Therefore, one would assume, in an analogous way to the remedies that are available against a true trustee. One turns back very slightly to a short academic article, which was, it's been included for the appeal because it was referenced to the judge. In the Cambridge Law Journal, page 249. The view very much being propounded by the author, see the paragraph alongside the first hole punch down on page 250. It's endorsing the view that when it's been said that a knowing recipient should be liable to account as a constructive trustee, that should be exactly what the assertion means. You've got custodial duties that are actually of the same nature as those which have voluntarily been assumed by the express trustee. So the express trustee has got prior duty. But it goes back to the way I put it. Why has the knowing recipient got any appreciably greater virtue than the original defaulting trustee? Mr. Crosby hasn't.
Well, wait a minute. It says the knowing recipient is fixed with custodial duties of the same nature as those voluntarily assumed by the express trustee. Is that right? Why do you assume that a knowing recipient of trust property must be fixed with the same formal trusteeship duties as the express trustee voluntarily assumed? I mean, I thought that this was simply said to be a formula for equity to impose some form of relief.
Well, I would suggest that when it's being said of the same nature, that's in a qualitative sense, which aligns with the way I'd put it, which is, well, why has the accessory actually got any appreciably greater virtue than the original defaulting trustee? If he or she hasn't, why should there be a bifurcation of the remedies? Where do you start the bifurcation and why? The House of Lords in Dubai don't give a very good platform for that departure, and so it's absolutely plain and stark in novoship, but that doesn't mean it's beyond revisiting. Then we have the decision in Watson against Here Investments. Stay in this file, turn to page 283. Firstly, in the holding at the bottom of page 283, that's crisp expression of the conclusion. A knowing recipient of trust property, although not formally a trustee but only a constructive trustee, was liable to account for his wrongful receipt as if he were a formal trustee and in default. And then in the middle of that paragraph, the principles governing recovery of equitable compensation were not and did not need to be the same as those governing damages or restitutionary claims, i.e. you don't have to have the causation question. You certainly don't have to have it as a fixed intermediate step in the way in which the judge has it. Over at the top of 284, and then I'll go into the judgment itself. They've exposed themselves to equitable remedies by participation in the unlawful misapplication of the trust assets, and so they're accordingly liable to account to the trust to the claimants as if they were defaulting trustees. Then for a discussion of such matters, see firstly paragraph 40 on page 293. all of that being contrary to the later Noviship decision. Later in the sense that later than the 2014 Noviship decision, the one that.
Sorry, what?
Just let me.
No, it is
It's the same one.
same.
Is it the same 2014?
There is only one. Yeah.
That's a slip. Forget that entirely.
I mean, the more interesting point from that is that I'm not, to be honest, I'm not sure that in paragraph 40 of Watson, I'm not sure they've fully grappled with what Noviship appears to decide.
Well, no, forgive me. That's a simple confusion as to two Noviship cases. The nicotine is different. There is another one, but it doesn't intrude on this question.
But I mean, on the question of accounting for profits, how can you square paragraph 40 of Watson and Keogh with what is said in Noviship in the sections to which you referred us, where we want the Court of Appeal make it very clear that there is a difference between somebody who is a formal trustee or an express trustee, as they put it there, and somebody who isn't.
Well, I have to say it may not be correct. Noviship may not represent a correct statement of the law, and when we come to another point of departure on the next page. But we've already got Dubai Aluminium. We've potentially got Arthur, insofar as paragraph 34 helps, and then here the basis for the conclusion that this should all align and the remedies should be the same or available in the same way against the three, the fiduciary, the dishonest assistant and the known recipient. If one goes to paragraph 44, there's the introduction of the case of Docker against Soames, 1834, which is then addressed on page 295 in the highlighted section.
Bit at the end of the first paragraph of that quotation, is it?
Yes. Because, and the beginning of the second paragraph, that you have to give weight to the said undeniable principle of equity, which the way you police and discourage the way you police a breach of trust is that you have to both discourage it and then punish it. You discourage it by intercepting the gains, and you punish it by charging all the losses on the wrongdoer. And the need to do that to respond to equitable fraud arises as against a knowing recipient as it does against an original defaulting fiduciary. Then if we go back in the bundle to page 199, case of Keystone and Park. Paragraph 10. Paragraph 10, the rule of equity which insists on those who, by the use of a fiduciary position, make a profit. Now, of course, obviously, that Regal against Gulliver is directed to a fiduciary. They have to give up the profit. It in no way depends on fraud. Doesn't seem depend on questions about where the profit would have gone otherwise, who would have made a profit otherwise. The liability simply arises from the mere fact of a profit having been made.
That's a sort of but-for test.
Yes, simple but-for test.
So that's for a fiduciary.
That's for a fiduciary.
So I'm on sort of feeling a bit more on solid ground there when
Yes.
thinking there's a but-for test for a fiduciary. But for your breach of trust, express trust, a profit would not have been made.
Yes.
You must account.
And the judge in this case said that's not enough. You need to go further. You need to introduce a common law causation question. That's 2131.
Yes, which followed novership, that's what novership seems to say.
Well, I say there's a nuanced difference, which is that when the Court of Appeal say there's no reason why not, the judge actually reverses that. But that may be a fine distinction. We've been over that. Then the policy is to strip away the unauthorised profits, paragraph 11. But paragraph 15, the single point in issue in Keystone and Power is the appellant was saying, yes, but the company that suffered the loss here is not the party to whom I owed the fiduciary duty. So yes, I was a fiduciary, but I owed the duty to the trading company, whereas it's the holding company to whom I was not a fiduciary, which has made the loss. Therefore, you can't take the secret profit away from me.
But this is a very different sort of case. The Keystone is a different issue. Keystone is, I owe the duty to company A not to make a profit from my position as a fiduciary owing duties to company A. I've made a duty using my position with company A. It just so happens that the loss has been felt by company B. Well, so what? You've still got to account for the profit to company A.
But at one and the same time, it's considerable damage to the causation element.
But the point being here, you're still dealing with an express fiduciary who's breached his duty to
somebody else. And a different legal entity, separate legal personality.
He owes a duty to the entity that sued him not to make a profit from his position, and he did. The fact that the beneficiary of the fiduciary duty didn't itself suffer the loss, and the loss was suffered by somebody else that hasn't sued, is neither here nor there. I mean, it's well established that if a fiduciary makes a profit, the fact that even the beneficiaries haven't suffered a loss is no bar to recovery. I mean, that's back to Regal and Gulliver.
Yes, but 15, I'm saying, introduces damage to the causation question, because it was partly by reference to it's not a question of causation. You've got a duty to account, and you can be made to disgorge completely aside from questions of what would have happened anyway.
Absolutely, if you're an express fiduciary.
Yes, which Mr. Parr was not in terms of the effective complainant, the one that had suffered the loss and the one that was bringing the claim against him.
No, the effective complainant was the person who says you shouldn't have made a profit on my watch. You know, when you're supposed to be acting for me and you've made a profit for yourself, I don't care where the money's come from for you to make a profit. You have made a profit using your position as my fiduciary. Give it to me.
Yes, I'm relying on 15 and 17 to reinforce the proposition that causation is not a material part of the exercise. I and perhaps on better ground on Watson and against Kier Investments in terms of the tension, supplemented by the introduction in Dubai Aluminium, which of course is the most authoritative approach of all, but it probably doesn't, on the facts that were in issue in that case, grapple with the finer question that was being looked at by the Court of Appeal in Novaship. May I just check one note I have about Akin Daly? Yeah, so what we submit in conclusion on ground 9 is, if it's unconscionable to keep the money and you are therefore guilty of an equitable fraud, then you are actually also liable to have the profit that you make stripped from you. And the judge's introduction of a causation question, whether faithfully by reference to Novaship or not, is incorrect. May I just finally, because I left this out of the account, mention Fifes against Templeman, third volume of Authorities, page 986.
Sorry, can I? I'm sorry. Before you do, can we just go back to Novaship a second? Because in 107, is there a point? Maybe this is the point you're making. But in 107, it says Mr. McKeaton is not sued for breach of fiduciary duty. He is sued because he's committed an equitable wrong. Where a claim based on equitable wrongdoing is made against one who's not a fiduciary, we consider that, as in the case of a fiduciary sued for breach of an equitable but non-fiduciary obligation, there's no reason why the common law rules of causation, remoteness and measure of damages should not be applied by analogy. We recognise that these rules do not apply to the case of a fiduciary sued for breach of a fiduciary duty. Is this saying that because this was a dishonest assistant who's not a fiduciary, you apply the sort of rules of causation, remoteness and measure that would be applied where, for example, a fiduciary is sued for breach of an equitable duty of care? But is Novaship actually saying anything at all about questions of where a knowing recipient is sued for an accountable? It doesn't say anything about an accountable
I think
profit.
it does cover, it does refer to rules being the same for knowing recipients somewhere.
I think that may be 82.
I think they come back to it.
You see, it's hard to penetrate because the messages do appear to be slightly mixed, because on the one hand at 82 it's saying that both the knowing recipient and the dishonest assistant have the responsibilities of an express trustee, so they should be treated as akin to a trustee. So then it becomes even harder to identify where the point of departure is in terms of the remedies against the three types of people. And paragraph 71.
I was thinking of 86.
Sorry.
Although I think that may be
Yeah.
limitation. I think they come back to it.
Because I think Williams and Central Bank was a limitation case.
Yeah.
This was a case where the third party had bribed the fiduciary to get contracts and made profits on the contracts. Is that right?
Yes. Yeah, it was fraudulent arrangement of charters, and then the conclusion is, well, there ought not to be, there doesn't need to be a disgorgement of profit, because in fact the money that's been made it's really regular commercial activity, and it's just because you've had the opportunity, which you've dishonestly obtained for yourself in order to engage in the activity, that doesn't mean that you're liable to have everything stripped. Could I take the court back to paragraph 71? There's a body of modern case law which recognises that the court has the power to order an account of profits against a dishonest assistant, even where no corresponding loss has been suffered by the beneficiary. I say extend that to knowing recipient. That's as far as we need to go, that you can have a liability for an account of profits if you're a knowing recipient, and that all three should align: defaulting fiduciary, dishonest assistant and knowing recipient, for the reasons that we've looked at. Paragraph 75. Accountable in equity, fine, but what does that mean? Is it the limit of the liability to make good losses? No, it's not. It's a liability to make good loss and a liability to account for profits. That, I would say, is consistent with Docker and Soames. And you shouldn't take the account of profits off the menu as against a knowing recipient. There's no good reason in principle to do so. Paragraph 82, endorsement of the correctness of the proposition that a dishonest assistant and a knowing recipient do have the same responsibilities as an express trustee. That, if that's correct, why the point of departure on remedies? And then paragraph 100.
Well, the conclusion at the end of 84, which is the point, is where an equitable wrong is itself linked with a breach of fiduciary duty. So that's the dishonest assister, or you'd say for the purposes of current argument, the knowing recipient,
Yes.
who commits an equitable wrong, if that's what a knowing receiver does. We see no reason why a court of equity should not be able to order the wrongdoer to disgorge his profits insofar as they are derived from the wrongdoing. So you wouldn't disagree with any of that. In fact, you'd say, yeah,
Yes.
absolutely.
Yes.
But then the question is, what's meant by derived from? And that's where you say the court bill begins to go awry, because they adopt a different test for derived from when you apply it to a knowing recipient than if you apply it to a express fiduciary.
Well, I have said that, but I've also said that you don't actually need to go that far, in that you can have a question of discretion. What is a matter of discretion is the right remedy on the facts of the case, as against whichever type of accessory you're dealing with. What I'm saying is you don't remove the liability to disgorge profits from the discretionary exercise, and you certainly don't kill it off by an intermediate common law causation test, as the judge, I say, has applied, and the Court of Appeal in Noviship do not, I say, necessarily say that. They just say
the Court of Appeal in Noviship at 84 accepts that, subject to what you mean by derived from, you can order an equitable wrongdoer, which you say encompasses a dishonest assistant and a knowing recipient,
yes,
to disgorge profits.
yes,
So far so good at 84, you say. Is that right?
yes.
Right. So
Then I'd move to 100, and then we get close to the passage where we started. But I wanted to pick up 100. And this is an equitable principle which applies, we say, to all. And so in terms of how and why it applies, it's because it doesn't depend really on an absence of bona fides, although we're criticising Mr. Crosby for exactly that. Doesn't matter as to where would profit have gone otherwise. Could the complainant have otherwise made profit? Those things don't matter. The liability arises from the fact of the profit having been made. That is up for grabs, subject to proper discretionary limits on the facts, as against all three: defaulting fiduciary, dishonest assistant and knowing recipient. And the judge was wrong to conclude otherwise. Docker and Soames hasn't got the consistent attention it possibly deserves in the way in which it's given attention in Watson and Keir Investments, but Watson and Keir Investments is a very important plank of the argument. Together with Dubai Aluminium, because of its source being a House of Lords decision, and then to a lesser extent the limited contribution made by the Privy Council in Arthur. Then finally, and then I'm on the last grounds, and I can pick up a bit of speed. This was always going to be quite a substantial ground, but Green and Wetherill, just to complete the picture. First volume, page 272. This is authority for the proposition, at 281, for that there is a duty to account as a trustee for subsequent dealings with the assets that you have knowingly received in breach of trust. It's not a profits case as such, but it's about having a liability for subsequent dealings.
Which page?
Sorry, which page? 281, I think, of the authorities bundle. As against the defendant Mary Croft, the position is very different. She's sued as a constructive trustee. Those facts having been established, she must be taken to be a trustee. It's not alleged that she's committed a breach of trust. On the state of the pleadings, counsel would not be able to ask for an account of the sum received by her with notice of the plaintiff's claim. Not disputed that the sum paid is, and therefore an account against her is unnecessary. That I put forward at paragraph 55 of the skeleton as some support for a liability in respect of subsequent dealings after you receive knowledge, after you become a knowing recipient. The final thing I'd intended to mention, Fifes against Templeman, page 986, volume 3.
Sorry, which page?
My Lord, 986.
986, thank you.
It's a point against me to some extent. It's Mr. Justice Toulson concluding that he did not see the equity of ordering Sea Trade to account to Fives for that profit, a certain element of the profit. Liability of a fiduciary should not be transformed into a vehicle for unjust enrichment of a plaintiff. That's why there have to be discretionary checks on the potential liability. But nevertheless, I have submitted firmly in the appeal that it's wrong to say that there couldn't be a liability on Mr. Crosby and the first defendant to account for profits. I can do grounds 10 and 11, hopefully in the 15 minutes available. But certainly grounds 10 and 11 can be taken together. Ground 10 is that there was, in fact, before the judge, a clearly sufficient coordination for the purposes of backwards tracing. Ground 11 was to say that he was wrong to introduce the possibility that there would not have been a coordination if, in fact, events had been different. But we say, what did that matter? The events were as they were, and then either you've got a good backwards tracing claim or you haven't. The starting point here is Mr. Crosby's affidavit at paragraph 35. Supplementary bundle, page 144. For what it's worth, I don't place any particular weight on this, but the judge in refusing permission to appeal himself said he may have been minded to give permission on the question of backwards tracing, but ultimately it was academic because he found no breach of trust and no knowledge. There was some interest in, to say the least, in terms of how backwards tracing could work and how it could work against the facts of this case. But the start point is paragraph 35 on page 144. Mr. Crosby says, I identified a property called Vinesgrove. It was my intention to purchase it using the proceeds of the sale to McDonald's. However, the sale dragged on, and so I had to take out some bridging finance. Staying in the supplemental bundle at page 14, we have some email exchanges between Mr. Crosby and the lender. Bottom of page 14 is George wants to push the 6 months to 12 months to give him some room on the McDonald's deal. I think it may be better if I let you both speak to each other to finalise that. The judge in his judgment at paragraph 224 says, had Vinesgrove been purchased with the unequivocal intention that it be paid for out of the proceeds of sale of Mercury Way land, and if the bridging loan had been taken out on the basis to bridge the gap until sale, I consider Mr. Crosby would have had some difficulty in saying that the SPH Trust was not entitled to backward trace. But that was Mr. Crosby's sworn evidence in an affidavit. The judge at paragraph 223 correctly...
So what's paragraph 70 of Mr. Crosby's witness statement? Where's that?
That's probably the same point as I just made in the affidavit, but it is.
Yeah, well, that's what I wonder, because that the judge seems to accept that if taken on its own, paragraph 70 of Mr. Crosby's witness statement would seem to support that result. If 70 of Mr. Crosby's witness statement is very similar to 35 of the affidavit you've just shown us, then the judge has taken that into account.
Yeah.
Then he goes on. The position is more complex.
Yeah, it's actually not quite the same. I mean, some elements of the affidavit had been watered down by the time of trial, but your Lord's quite right to ask for the reference. It's in the supplemental bundle at page 185, paragraph 70.
Just give me 1 second. Well,
it's more or less the same, but it's
I mean, it's materially the same, isn't it, for the point you wanted to make? Is that right?
I mean, the affidavit was and remains clearer, but I agree. I'm not dancing around here. It's the same point. I quite agree.
I mean, the paragraph, the sentence in the middle of 35 that you particularly place reliance on, it was my intention to purchase Finesgrove using the proceeds of sale to McDonald's, right? And that appears precisely the same in paragraph 70.
Yeah, it was the proceeds that were earmarked for the funds to buy Vinesgrove. Now, where the judge went wrong is because he'd been seduced by what I've described as a flight of fancy from a learned friend, which was in my learned friend's closing submissions at paragraph 64, page 288 of the supplemental bundle. Six or seven lines up from the foot of that paragraph, my learned friend submitted to the judge it was merely an accident of timing that resulted in the proceeds of Mercury Way being used to discharge the bridging loan. And we say that's just simply not correct and was not borne out by the evidence. In our closing, or closing speaking note, see page 300, paragraph 38.
Yeah, but what the hang on, wait a minute. What the judge is saying is that it's subsequently. Sorry, just give me 1 second. The judge is there referring to the very email that you took us to. He says, I consider the contemporaneous correspondence, and particularly Orton Ainsworth's email dated the 23rd of August, and the fact the bridging loan was secured on the Dane Road property in Vinesgrove, but not Mercury Way, supports what Mr. Crosby said, to the effect that Vinesgrove was required to replace the Dane Road property as the current home. In other words, that I think what he's saying is that there's a change of plan. I mean, it might originally have been intended to use the proceeds of sale of Mercury Way, but it couldn't be done, so they didn't even secure the loan over Mercury Way at all, which is the one thing you would have thought that they would have done if that remained their intention. words, by the time the transaction is actually carried out, the intention is not to use the Mercury Way proceeds, because it's not even offered as security for the repayment of the bridging loan, but to use some other source of funding.
Yeah, but it's, unfortunately, it's just not correct. There's another aspect entirely, which is this bringing in of the idea that, oh well, it's.
So what's not correct?
Well, firstly, there were two lots of bridging finance. One was secured against Vinesgrove by Mr. Crosby personally, and the first loan was secured against Mercury Way by the first defendant. That there were two aspects of bridging finance. We've got the documents in the bundle. So that's the first problem with the judge's departure. He had no basis for pulling away from paragraph 35 of the affidavit. But that wasn't really Mr. Uff's point in any event. What Mr. Uff was trying to submit was that it just happened to be an accident of timing that the proceeds of sale to McDonald's ended up being used to discharge the loan. So he is accepting that the McDonald's monies discharged the finance, and he was submitting that, well, yeah, but that was just an accident, because what was really going on is that they're just trying to swap the family home for another. And
but if it was not always intended to use the proceeds of Mercury Way to discharge the bridging finance, then how can you backwards trace?
well, because it was. That's what Mr. Crosby told us in his affidavit.
No,
The proceeds were always earmarked to buy Vinesgrove. The McDonald's monies were going to be used. However, it dragged on. We're selling to a large international restaurant chain. It dragged on.
so
There was a planning block. Peel put a planning obstacle in the way. McDonald's got over it. Something of that nature Mr. Crosby talked about. So I had to take out bridging finance.
Yeah.
But as soon as the sale proceeds came in, they were used to clear the bridging finance.
Well, they were, but in between, security was given over, according to the judge, and is this right? You say wrongly, over two other properties. I fully understand that if you say there's an intention to use the Mercury Way proceeds to discharge the bridging finance and security is granted over Mercury Way,
Which, as a matter of fact, it was.
Well, so
secured by the first defendant. I'll take your lordship to the document in a moment.
yeah, but sorry, can we just get this clear? 'Cause are you saying that there's an error in the judgment at 224, a factual error?
Well, it depends which bridging loan is being spoken about, because the bridging finance, it was not just to cover the gap, but it was also to repay the capital to the trust. So that was 645 in itself. The reason why the judge got dragged away from paragraph...
No, you're tracing... No, wait a minute. Here you're trying to trace into Vinesgrove, right? So the bridging loan that we must be talking about is the bridging loan that's taken out to purchase Vinesgrove. That's what your claim is about. So the question is the only relevant bridging loan for the purpose of this bit of the claim is the bridging loan taken out to purchase Vinesgrove, correct?
I would say not necessarily, because they're virtually done at the same time, and the reason why there has to be two is because there's a limit to the security, and he had to get the money to repay the trust at the same time. So he has to get the money to buy Vinesgrove, which was several £100,000, and he has to get the money to repay Mr. Shovlin. And one's dated the 13th of September, and the other's dated the 4th of October. So he has to bridge in two respects while he's waiting for the McDonald's sale to go through.
But the point is you are trying to trace for proprietary purposes into Vinesgrove. So you have to be able to, to join the dots sufficiently clearly between Mercury Way and Vinesgrove, correct?
Yeah, but when you take out two loans at the same time, because you need two separate loans because you've got mixed security that you can give in order to get the money from the lender, and they're virtually simultaneous. And your sworn evidence is, I'm going to buy Vinesgrove from the sale proceeds. But not only do you have to cover the gap in time while you wait for the sale to complete, but Mr. Shovlin pops up and says, I want 645,000 back or else. No wonder there's a mix of the security. I mean, part of the security for one of them is Vinesgrove itself, even though it hasn't been acquired. So the judge was wrong to place significance on merely that, to pull away from paragraph 35. But my learned friend's real point, and the one that the judge accepted, was it was just an accident of timing.
No, the real point the judge accepted that was made is in the bit that you didn't read to us in paragraph 64 of the closing submissions, which preceded the sentence you did.
But I'm still very interested in the other part, because...
Yeah, but the judge accepted, I mean, you pointed to the sentence, it was merely an accident of timing, but you ignored the earlier part of paragraph 64 of the closing submissions, which is the basis on which the judge decided the case. He said, I do not allow backwards tracing because it's not as simple as in the paragraph of the witness statement, because in fact, the bridging finance used to acquire Vinesgrove, which is what you want to trace into, was not in fact secured over Mercury Way, but actually secured on other properties, and so there's no sufficient nexus between the acquisition of Vinesgrove and the interest which you assert over Mercury Way.
Yes, and I wasn't trying to shy away from that sentence. All I'm saying is that is merely happenstance, because if you need the money to tide you over so that you can buy Vinesgrove while you're waiting for the McDonald's money, and you also need to find an extra 645,000 on expensive bridging finance to repay the trust, what's given as security for what when the two aspects of finance are taken out at the same time? Really neither here nor there. That's simply happenstance as to the way you get the money. So that literal mismatch does not defeat backwards tracing, because they're simultaneous. Where we think the judge was successfully dragged away from paragraph 35, which had always earmarked the McDonald's monies for Vinesgrove, was by saying, oh, well, it's something to do with replacing Dane Road as the family home. But that argument...
But on that, the email to which you took us earlier evince an intention to repay the loan first from the sale proceeds of the previous house, Dane Road. And that's what the judge is relying on.
But what the judge has left out of account, and what my learned friend left out of account, is paragraph 95 of Mr. Crosby's witness statement, supplemental bundle page 188.
You accept my lady's point, though, that the
yes.
Email, paragraph 14, 2 sentences up from the one you took us to, is that the assumption is that the repayment of the bridging finance, presumably this is to purchase Vinesgrove, will be repaid after sale of current home, which is what they took security over.
I do accept that intervention, but we still, I say, are not into a successful drag away from paragraph 35 of the affidavit, because if you look at the witness statement, page 188, paragraph 95,
And when's the timing of this bridging loan? When was the bridging loan actually taken out? The one to purchase Vinesgrove? Because the timing might be important.
yes, well, I think I said 13th of September and 4th of October. Yeah. And then we have a chronology in the core bundle at page 71,
Okay.
which hopefully descends to this level of detail. I'll just check that it does. Yes, it does, at page 72.
Well, hang on, the bridging loan?
So Vinesgrove completes on the 10th of October 2019. So
And Dane Road is not even on the market then. Because paragraph 95 of Mr. Crosby's witness statement, page 188, it was deliberately retained,
yes, but
even
that's-
after the purchase of Vinesgrove.
But the decision to separate, which you might think is a new thing, that might affect matters, was in November. And you've just established that Vinesgrove was bought in October.
Yes. So, even when the McDonald's money came in March 2020, Catherine is still living at Dane Road. That was not sold until July 2020. And she then purchased her own property with a share of those sale proceeds in October 2020. So Dane Road is not even on the market while he's waiting for the McDonald's money. He was right first time round. The McDonald's money was earmarked for Vinesgrove, and the intervention of the bridging loan is not sufficient to disturb that.
Well, no, it wasn't earmarked. I mean, that's exactly the point. What was earmarked for the purchase of Vinesgrove, or the repayment of the bridging loan, was Dane Road, because it was charged. I mean, that's what earmarked means. You charge Dane Road as security. You earmark Dane Road with the repayment of the bridging finance for Vinesgrove. That's what they did.
Well, we say you just had to find all the security that was available. So the security was, Vinesgrove was security itself, even though it hadn't actually been acquired. You've got Mercury Way as security for the other tranche of money, and then you've got Dane Road, which is the only other available security. You've got to get the money in. You've got to get the money in for two things. I'm going to go ahead and buy Vinesgrove because I've wanted it, and I've wanted to use the McDonald's money to buy it. I can't use the McDonald's money to buy it because I've had to wait. And at the time of having a need to give security for borrowing, I've had Mr. Shovlin pop up who wants another 645,000. So I've got to find security for that too, because nobody will possibly give me this sort of money on an unsecured basis. And we're back to where we started this morning. But what the judge has not brought in is it's dangerous to just say, oh, well, it's all an accident, it happened this way. My learned friends seem to be saying it happened in such a way that I could be.
Sorry, the judge didn't say it was an accident. It all happened.
Well, no, Mr. Off submitted to the judge that it was an accident.
Yeah, but the judge didn't. That wasn't the tributary which the judge went down. The judge went down the first bit of paragraph 64, I think it is, of the closing submissions. I mean, he looked at what had been charged to support the bridging loan used to acquire Vinesgrove, and you said he was wrong, and I don't think he is.
Well, that's
in his factual statement. You said he was. I don't think he was. So the question is he wrong as a matter of law or judgment, whatever backwards tracing involves, probably, to place reliance upon the fact that the bridging finance was not secured on Mercury Way, but secured on some other property?
That's not enough to deny a sufficient coordination for the purposes of backward tracing. Start with the affidavit, absolutely clear, only capable of one meaning. You take account of the reality of the situation as to why there has to be double bridging finance and how you have to spread the security. Because you need more than you thought you did. Because you're not just buying Vinesgrove, you've got to repay a trust. It's a liability you didn't think you were going to meet then. So the mismatch between the security should not defeat backward tracing, particularly given the coincidence in timing. Then insofar as you try to use Dane Road and say, no, hang on a minute, Vinesgrove was simply intended to be a swap for Dane Road. That's not what the evidence said. Dane Road is still not on the market, even after the McDonald's sale is completed in March 2020. Catherine carries on living there until July 2020, and it's eventually sold in October 2020. So you can't use the Dane Road was intended to be swapped as Vinegrove to defeat backwards tracing, and the mere manner in which the security was split across the two sets of bridging finance doesn't do it either.
When did Mr. Crosby and Mrs. Crosby separate?
November 19, they agreed to separate, according to that evidence.
The evidence was that there's the decision to separate. Whether they did it straight away or after a time, we don't know.
It can't have been particularly acrimonious because she's still living at Dane Road in July, and then it eventually sells, and then she buys a property out of the proceeds of Dane Road for herself. But okay, the separation is an unanticipated intervening event, but it's still a fallacy to say, no, Dane Road was supposed to swap for Vinesgrove. Look at how the security was arranged. That's not correct. Mr. Crosby had given the game away faithfully in his affidavit, and there was an attempt at trial to row back from the reach of backwards tracing, because backwards tracing says step back, was there a sufficient coordination in reality?
Right, we've got a bit over the time. Have you now made your points that you want to make on backwards tracing?
Yes, there's no need to go. The two cases which I've cited in the skeleton, Eladju and SFO and portfolio, the reasons why they are relevant are in the skeleton. I don't need to add to that. The only other thing, I think it's a matter of reply in any event, is as to the respondent's notice, but I should probably wait and see how my learned friend develops that tomorrow.
Yes. All right, well, we'll adjourn now and find out what Ms. Truff is going to say tomorrow at 10:30.
Court rise.